Welcome to our coffee break webinar, the first in our series of lockdown learning. My name is Elaine Brailsford and I'm joined by my colleague Stephanie Hepburn, and we're
Hi.
both members of Shepherd and Wedderburn's Rural Dispute Team. This morning we are going to talk about encroachment and remedies. It's a topic we are both very familiar with, having dealt with quite a number of cases about encroachment.
Yeah, that's right. So just back in February there, we spent 2 weeks in the Court of Session arguing for the removal or cutting back of quite substantial and costly extension that a neighbour had built in an area our client had a right of access over. We've also had recent experience involving cycle paths that were built by a local authority on our client's land, a shed being built where it shouldn't have been built, which had the potential impact on the development of our client's site. I've also got an ongoing case about a driveway being built allegedly on neighbours' land, and experience of lots of similar disputes we'll talk about over the course of the webinar.
So often encroachment occurs because there is a degree of uncertainty as to where the title boundary actually lies on the ground. And this can be a very tricky area, especially when you're dealing with plans and maps that have a large degree of tolerance. So knowing just exactly where your legal boundary lies on your ground can be difficult and therefore can lead to problems of encroachment. And sometimes the dispute is actually about the boundary in your title. The keeper may not have plotted it correctly. And in our driveway case that Stephanie's just mentioned, our client is arguing that his neighbour has encroached on his title by putting in a big sweeping driveway. But the neighbour is seeking to rectify our client's title, arguing that our client's title has an error in it and that it doesn't accurately reflect the proper legal boundary.
That's a good example of a title issue, but it's not always a title issue. So in the recent Court of Session case just before lockdown that I mentioned, our client's complaint was that an extension that the neighbour had built obstructed on our right of access our client enjoyed, and he said that obstruction was material. So in this case, the neighbour's extension had been built to about only a few centimetres from our client's gable wall. Our client's title showed the gable wall of our client's property that was about 300 years old, sitting right up to the boundary of the client's title. Whether that property was originally built to the boundary or if it had been sort of split off after it was built, we couldn't actually determine because the deeds were so old. But in that case, our client claimed he had been using a passageway that sat on the neighbour's land to access the gable wall of his property for maintenance purposes, so for repair of and painting of the windows in the wall and things like that. And he said he had been doing that for more than 20 years and had acquired a prescriptive servitude right of access to maintain that wall over the passageway that sat on the neighbour's land. And when the extension was built, because it was built on the passageway, our client argued that interfered with the right of access our client enjoyed and effectively encroached on the right of access.
So what then are the remedies when somebody has encroached upon your ground or upon your right of access? Well, there's two kinds of possessory remedies. One is to stop the encroachment and retain possession, and the other is to recover possession. And much will depend on what stage the encroachment has reached. So, for example, if you know that plans are afoot to build something, in our recent Court of Session case with the extension, our client had notification of a planning application, and so he could see that the neighbour was planning to put an extension almost right up to his gable wall. And construction had not yet started. So interdict would stop it, and that would be an appropriate remedy. Interim interdict could be sought to preserve the status quo. So while the matter is argued out and determined by the court, things are left as they are. So interdict stops the defender doing something it cannot be used to make the defender do something. So the timing of obtaining an interdict is important. If the building is completed, then interim interdict is not going to do you any good, because you can't use your interdict to make somebody take it down. It can only be used to stop someone doing something. So interim interdict may sometimes seem the obvious remedy to prevent that building being started and to maintain the status quo, but it's not without risk. Interim interdict is granted on what we call ex parte statements. That means that what we say to the court has not yet been proved, but the court will accept what we are saying as if it is the truth. And that means that if the underlying question is finally determined against you in court, then you will have been wrong. You will have really participated in a wrongful diligence by seeking interim interdict. And accordingly, you will be potentially liable for damages. The cute little Latin phrase that's used is that the order is granted periculo patentis. And that means
like a magic spell than anything else, I think.
Well, it sounds like a magic spell, but what it really means is that it is at the pursuer's risk. So if the pursuer fails in the end of the day to prove his rights, then he could end up liable in damages. And you can imagine that if you've just stopped an expensive, potentially substantial piece of construction, the damages might well be substantial. The neighbour who has been stopped by interim interdict might find that he is faced with a breach of contract claim by his builder. There may be increased costs. The damage might be considerable. So in our extension case, we didn't seek interim interdict. Now, it is sometimes a very fine judgment call to make, because clearly stopping someone in their tracks can bring them quickly to the table, and it can allow matters to be resolved through negotiation. On the other hand, allowing the other party to continue with the wrong, providing you let them know that you are asserting a right, transfers the risk to them. So if ultimately you obtain an order for removal, which is the second remedy that Stephanie will talk about, the removal will be at their cost.
So before we go on to talk about that, just a quick word about the question of delay and this transfer of the risk. Elaine, you mentioned this proviso that you must assert your right. So what that really means is you can't just sit back, you can't just let them get on with the build, in our case it was the extension or whatever the encroachment is, and say nothing, and then when it's all complete ask them to take it down, because if you do that, there's a real risk you may be found to have acquiesced or tacitly consented. The argument against you is really that a reasonable person would have taken action much sooner, and as a consequence there's been this acquiescence or consent. It doesn't really mean taking action, doesn't really mean in this sense going to court. It just means that you're asserting your right, so that the defender, the other side, is in no doubt about your position. So you can't be said to have just stood back, let it happen and said nothing. The second remedy that we've mentioned is for removal, and like interdict, it's also possible to seek an interim order of removal, and again your magic spell comes in, and that would be granted periculo patentis. Removal is, in fact, the primary remedy, but it is a discretionary remedy, so the court does have the discretion not to order the removal of a building.
But there is a common misconception that once something is built, you're never going to persuade the court to grant an order for it to be taken down. Just discussing our case with the extension with our colleagues, our non-litigation colleagues, that's certainly what they thought. Oh, you're not going to succeed here. You'll never get the court to take it down. I mean, it was, after all, a beautiful, well, there's a matter of opinion. There's divided opinion about that. I thought it was a pretty beautiful, modern, classy, completed extension. And the defenders clearly thought so too, because they sought to rely on the court's power to refuse the order sought, and they asked the court, do not grant an order for removal. But the power to refuse such an order has actually been held by the courts to exist in only exceptional circumstances. That's why I think Stephanie said that removal is the primary remedy. When the exact restoration of things to the condition they were in before the encroachment, where that's impossible, or where it would be attended with unreasonable loss and expense, which would be quite disproportionate to the advantage which would give the successful party, then the court might exercise its discretion and refuse the order. But it's not just a question of proportionality. The courts have said that they also have to be satisfied that the encroachment has been made in good faith and in the belief that it was unobjectionable. So that goes back to the point that Stephanie made, that you must make it clear that you are objecting, that you believe your right has been infringed. Because then, if the encroacher carries on regardless, and that's sort of what happened in our case with the extension, then he may not be able to avail himself of an argument that the court should exercise its discretion and refuse the order of removal. And if the encroachment is inconsiderable and doesn't materially impair the proprietor in the enjoyment of his property, and that the removal would cause the encroacher a loss wholly disproportionate to the advantage that the encroached person would gain by the removal, then the court might exercise its discretion. But the defender has to bring himself within each of these considerations, not just one of them. It's not enough to say, oh, I spent a ton of money on this extension, totally disproportionate for me to take it down just so you can go and paint your gable wall every 10 years. That, we would say, is not on its own sufficient.
So the final remedy then is, of course, damages. It's often difficult to quantify in monetary terms the loss that's suffered as a result of an encroachment. And that's actually why the primary remedy will be the possessory remedies that Elaine has mentioned. Certainly in our most recent case with the extension, the client didn't want damages. He just wanted the extension to be removed and the encroachment to be removed. One way of quantifying your loss is to say that you've really lost a chance to demand payment for the land that's been taken by the encroachment or for the exercise of the right to obstruct. Sometimes the encroachment can create like a ransom situation, and the extent of damages sought can often be based on a Stokes v Cambridge principle. Other times it might not be a ransom situation, but nonetheless there may be an amount which the encroacher would pay to keep the encroachment where it is, based on the cost of having to remove it plus some sort of margin on top. And that's usually called a frustration payment. The person whose rights have been encroached upon has lost the chance to reasonably seek that amount from the encroacher. In our case that I mentioned, where the local authority had built the cycle path on our client's land and encroached on our client's land, the area in question wasn't all that substantial. The land wasn't worth that much at all, but the argument we ran was that the council, having built the path, had created a need for the land, which has become more valuable as a result. And in assessing an alternative claim for damages in that case, we assessed and had valued what it would cost the authority to have to take the path out and assess the damages based on that basis. There's also English authority. You can take into account the extent to which the encroached piece of land enhances the amenity of the encroacher's property. There was an English case about a swimming pool that had been built on neighbours' land and encroaching on neighbours' land, where that valuation approach was taken.
So I'm sure you're all dying to know, will our client with the extension 4 inches away from his gable wall, will he be able to maintain it? Will he be able to paint it in 10 years' time? Well, I think you're going to have to tune in for the answer, because we are still waiting the decision of Lady Carmichael. Hopefully this period of lockdown and relative inactivity in the courts has meant that she's had time to consider all the arguments.
Hope so. I'm dying to know as well, so I hope so.
So we'll give you an update when you next tune in. So that's our coffee break over. I hope you've enjoyed it and found it useful. Please join us again for our next coffee break webinar, which will be on Wednesday, 3rd June, when we will be talking about servitudes and car parking. Or feel free to contact either Stephanie or I for a virtual coffee anytime. We're always looking for an opportunity to have a chat. Thanks very much.
Thanks. Bye.